So hello, and thank you for, first of all, for being here, and the viewers for joining us online for Canntelligence Forum, legal perspectives on medical cannabis. And we're gonna have a nice casual discussion today with two very accomplished attorneys. I'd like to tell you a little bit before I tell you about our guests, about our company. So Canntelligence is located here at the University of Houston Innovation Center. We actually have a lot of viewers around the world, so just to give you an idea, it's extremely hot and humid in Houston right now. And we are located in a spacious and airy innovation center here at the University of Houston, where there are several companies and startups. And so it's our pleasure to host these monthly forum events and discussions with the community and with the experts on different aspects of medical cannabis, laws, science, business, and other aspects as it relates to medical cannabis and cannabis business. So I will first introduce Lisa Pittman. Thank you very much for being here. Lisa is actually a graduate of the University of Houston Law Center in 2001, and following that, she was working a lot as commercial business, trial, and appellate attorney for over 15 years, 16 years. And in 2016, Lisa founded a group called the Well Women Group, which is an alternative healthcare community run by women and for women that provide a fresh approach to going back to the doctor and different wellness approaches. And Lisa has been very intimately involved with medical cannabis and cannabis laws here in Texas. And she has been serving as special counsel for Feldmann Nagel as a legal cannabis law special counsel. It's a company that's located in Colorado, one of the leading companies in the cannabis business area. So it's really a pleasure to have you here. And I will also, after a short introduction, will give you a word to say about yourself or maybe your interest or involvement within medical cannabis or within patent and trade secrets spheres. Now, the reason why I bring that up is our second guest is Dr. Benjamin Adler. Dr. Benjamin Adler has a practice that specializes in preparation, prosecution, securement, and licensing of patent applications. And he holds a PH.D. and he's completed, my text got cut off, but can you remind me your PH.D. is in? Molecular pharmacology. And so a lot of the patent work that he does, maybe he'll tell you in more detail, is about biological, molecular, chemical, and other aspects. He did postdoctoral training at the Memorial Sloan Kettering Center, Cancer Center, and he's a graduate of Boston University School of Law. That's right, that's what got cut off too. So it's a pleasure to have you here, really, and as you can probably tell by the introduction and the background, Lisa will probably concentrate, and I will ask questions of Lisa that are related more to medical and in general cannabis laws, and to Benjamin as they relate more to intellectual property. So we'll pass the microphone to Lisa just to say a few words about yourself, and we'll start from here.
Okay, thank you very much, Doctor. Can you hear me? Okay, great. Yeah, well, I was a commercial business trial attorney for 15 years when I kind of got fed up with the experience of going to the doctor and taking care of my children and my grandmother who was living with me. And as a lawyer, I could tell that doctors were practicing out of with motivations other than just what the patient needs or doesn't need. It could be fear of litigation, it could be insurance guidelines, it could be pharmaceutical pressures, and I wanted to create an environment where women could come and get some education and information about plant-based and natural health, nutrition, counseling, kind of a one-stop shop where they could learn about preventative ways to treat your body and things that you just don't get at the Western MD. So I believe both should be used in conjunction with each other. So that's kind of where my interest in cannabis began, because to me, cannabis is just another plant like lavender, peppermint, or coconut that has medicinal properties. And I had heard, or starting in around 2014, I started to see the videos circulate with the children with epilepsy and how this cannabis oil was assisting with their symptoms, or sometimes providing them a seizure-free life in some cases. And I had some personal motivation there too, because my own daughter had seizures when she was very young, and I took her to the top 2 pediatric neurologists in Houston, and I was given conflicting diagnoses, conflicting treatment plans, and one of them wanted to medicate her up to the gills and said, here you go, I'm sorry, but you're not going to have the same child after this because of all of the side effects of the medication. So when I was reading the Senate bill testimony for the Compassionate Use Act, which is what we have in Texas that was enacted in 2015, I read the mothers testifying about what life was like for their children who had 20 or 30 seizures a day, and what they were facing in leaving their communities, their churches, their families, their schools, to go seek treatment in a state where cannabis is legal, just to see if it'll work. And I could completely relate to that, because you will do anything to help your child. And I had to make those types of treatment decisions too, having 2 different, very well-accomplished doctors telling me 2 completely different things. And additionally, I volunteered at Texas Children's Hospital when I was a teenager and through college, and I developed long-term relationships with some children with cystic fibrosis because they come in again and again for treatment. But I also really sympathize with children with the chronic conditions and terminal conditions. And so that kind of played a role too in my motivation to learn more about cannabis. So I went to Denver to Women Grow Leadership Summit just on a fact-finding mission to find out more about cannabis for the Well Women group. And it was not, I wasn't intending to practice law in this area or anything, but the attorney in the office next to me told me how the law firm he does some military work for was looking to take their national practice, their marijuana practice national, and they were looking at Texas specifically, and they were looking to him to maybe get it off the ground. And he said, I don't know how I feel about that, Lisa, but it might be right up your alley. You should go meet with them. So while I was in Denver, I met with them, and we hit it off. We started a dialogue. Soon after that, they were approached by LSU to help it devise its program, that it was mandated as a suitable licensee under Louisiana's medical marijuana statute that was recently enacted. So I was hired on to begin work as controlling that project, to develop their business plan and instruct them from A to Z how to get a marijuana operation growing, and how to develop patents and make money off of that, and so forth. And thus began my complete immersion into the industry. And at the time, I just kind of hopped on the bus to see where it would go. And I've loved it, and so it's just been off to the races ever since. And I've gotten really involved in Texas, because trying to bring legalization to Texas, and working at the legislature, and working with the activist groups, working with business for their interests, and just everything having to do with cannabis law in Texas, I've been really focusing on.
Leslie called you the first lady of Texas medical cannabis.
Yes,
Texas
yes.
Cannabis. There was a recent article that was called that, actually.
Mm-hmm.
That's terrific. So maybe Benjamin, you can comment on your expertise and your perhaps relationship with how you see something, how it relates to botanicals and plants and the patenting world.
Sure. So first, thank you, Dr. Ziburkus, for inviting me to participate in this conference. I appreciate the time and the opportunity to lend whatever thoughts and experience I have on the matters. I am a patent attorney, former scientist, and my scientific interest is basis for my interest in cannabis patenting. As a scientist, I was interested in neurochemistry and neuropharmacology, particularly how drugs interact with receptors in the brain to function. And about 20 years ago, the endocannabinoid system was initially explained, and that is typically in receptor research and scientific research relating to drugs and chemicals and hormones, the initial step in developing drugs for a variety of indications. Once it's determined that a chemical has an endogenous binding site in the brain, that means that there are obviously functions that chemical performs within the brain, and opens the possibility of a wide variety of therapeutic options. And toward that end, I've worked for many years in patenting a wide variety of chemicals and other types of therapies, including in the cannabis field, and look forward, as this field continues to grow very aggressively, look forward to continuing that work.
Right. So if you don't want to just hold the microphone close,
Then everybody can hear us? Okay, good. So maybe we can start talking a little bit about Texas first, so we can orient ourselves in Texas, and we can also orient maybe Texas with regard to what is happening federally. So because you are the First Lady of Texas Cannabis, if you don't mind just giving us a brief overview of the history of prohibition in Texas and how it came about to the current very limited medical cannabis bill and its possible expansion during this special session, if there's a chance for it to be expanded.
Okay, well, cannabis has been illegal in Texas for about 100 years now. It's very illegal here. I mean, the mentality is just, it's different from other states, very conservative. So what we have right now is a very limited, low THC, high CBD type of cannabinoid oil that's intended to treat a certain subset of intractable epilepsy patients. And the way the law is written, it's not really even meant to provide a quality of life for children with any type of ordinary seizure. This is a last resort. Two specially qualified doctors have to concur. Brain surgery has to be ruled out. I mean, it's pretty dire. I spent a lot of time in the author of the bill's office trying to figure out, why this bill would not benefit my daughter and why she was opposed to any expansion of the bill or any changing of the language. So there's a lot of problems with the current law, the way it's written, probably intentionally not to function very well. And one of those issues is that doctors must prescribe this substance, which is a Schedule I substance federally. So it's federally illegal everywhere you go, even in Colorado, even in California, even if you're under a robust state regime where it is regulated, it's still always federally illegal. So a doctor is jeopardizing his license to practice medicine and his prescription writing privileges to write a prescription for a Schedule I substance. It's prohibited. So there's concerns how many doctors are really going to risk their careers and their livelihoods to write such a prescription. Other issues are that legislatively the THC component is only allowed to be 0.3%, and from what I understand, I know these gentlemen can talk about it in more detail, whole plant medical marijuana is really what benefits these patients, and that's why we have a lot of refugees, as they call them, children that have fled to Colorado to get treatment with whole plant formulations, and it's a very personalized process. So what works for one child may not work for another, but they can find different things that work for them in a state that allows whole plant medicine. So the current law is very, very restrictive. It was enacted in 2015, and that was the statute. So then after that, it's given to a state agency to promulgate regulations which determine how that program is going to operate. Most states that have some form of legalized medical marijuana, by the way, there's 30 of them, plus DC, and there are 8 recreational use states. In those states, they recommend medical marijuana, so doctors don't get into that problem of having to prescribe. And
what about the special session?
Special session. Oh yeah. Okay. So right now the law on the CBD oil, it is so limited. It was the regulations is what I was talking about. Other states where it's legal usually give this program to the Department of Health or maybe the Department of Agriculture. In Texas, they gave it to the Department of Public Safety, which is the law enforcement arm of the state. So that shows you the lens through which Texas looks at this plant. So it took them until February 2017 to finish their regulations. Meanwhile, in this session, a whole plant marijuana bill was introduced both in the House and the Senate. We had Senate Bill 269 by Senator Menendez and House Bill 2107 by Representative Lucio. And the House bill garnered unprecedented support in the legislature. Toward the end, we got to the Public Health Committee hearing. Patients and doctors and lawyers and parents and children came from across the state and from other states to come testify in support of this bill. After it got out of that committee, 77 representatives signed on as joint sponsors or co-authors of the bill, and that's almost unheard of. But it died in calendar committee because it is not on the governor's agenda to have medical marijuana on his watch, as he says it. So the senators and the representatives have both in a special session during the summer right now have reintroduced those bills. Representative Moody has also introduced a decriminalization bill. One of the medical marijuana bills is a lot more limited than the original one. It only allows for 4 conditions. Menendez, he introduced his full bill, but the special session is a very limited agenda. So the governor has a list of 20 items he's going to consider, and they have to do with the bathroom bill and abortion and all of these conservative positions. It's really not likely that there's going to be any movement on marijuana in special session. So they're giving it a go, they're making a run at it, they've filed the bills, they've done what they need to do procedurally, but unless in the political process it is referred for a vote, it won't happen. But you can call the governor's office and ask him to place it on his agenda. It's called the call, but unless it's on that call list of 20 items, it's just not going to go anywhere. And unlike other states that have voter initiatives, Texas doesn't have that. We only get our new laws through the legislature, which meets only once every 2 years. So this is really it until 2019. So everyone's got to go out and look at everyone's voting records and participate in the elections in 2018 and make sure we get the right folks in there who are not afraid to vote for marijuana in 2019. A lot of them are just afraid because of the conservative segment of the population that they'll lose votes in their next election, and they need to know from the public that they're not, that the public supports it. And in fact, a recent Quinnipiac poll shows that the public supports some form of legalization.
Great. So if I may add that at the same time, Texas Department of Public Safety issued 3 at least temporary licenses, but I think that they are proceeding, the licensees are proceeding with building their operations for low THC medical cannabis, at least in the extract form. There were over 40 applicants as far as we know, and 3 of them were successful more or less. But Department of Public Safety also mentions that they may expand the number of licenses. Then many people are wondering whether such limited conditions, with such limited access to medical cannabis for intractable epilepsy, only within a certain diagnosis and certain treatment regimen that you can have medical cannabis potentially. Is there a need for more than 3 dispensaries right now? And the other question that comes up often, I think, from the consumer's perspective, or from the patient's, in this case, perspective, is that the dispensaries are, 2 of them, I believe, are in Austin area, and 1 of them is outside Dallas, where we know the largest population is in Texas, and the largest epilepsy treatment center and the largest number of epileptologists are located here in Texas. And there's even a program that's ongoing with Epidiolex, which is a pharmaceutical form of cannabidiol, isolated from natural plant by GW Pharmaceuticals from UK, and that is ongoing in Texas now too. So from scientific perspective, we also wonder why Houston, Texas Medical Center, and why San Antonio and even Dallas medical centers are somehow left out of this. Do you have any insight about what people say on the Hill in response to that?
Yeah, so the good thing about the Texas statute is that it's unlimited licenses. So in other states, for example, Louisiana only allows 2 licenses. New York only allows 5. Typically, these medical marijuana states are very limited. Texas, fortunately, is unlimited. They have to issue at least 3. But as I mentioned, because the governor does not want any expansion of medical marijuana, he has kind of issued an edict that only 3. Okay, it says at least 3, only 3. So the DPS ranked the applicants. So the top 3 scoring ones just happen to place, up in the top 3. If they decide to open the program up to more licenses, they'll just go down the list to the other next high scoring ones. It's hard to say whether, it is difficult when the treatment is so limited, if they really need more dispensaries or not. It's the way the law is written is not ideal in that they're requiring their dispensaries to be at the cultivation facility. So as you mentioned, just having 2 in Central Texas and 1 in Dallas, that leaves a lot of surface area for patients to either travel, or the medication has to be delivered to their door by vehicle, which takes a long time. And what if the driver doesn't make it, or what if there's a delay, and meanwhile someone's health is at stake.
Delivery program that's built into the law?
They're not explicitly built into the law, so they kind of left that up to the creativity of the applicants to tell the state how they intended to ensure access of the medicine to the patients, because it is ridiculous to expect somebody from Amarillo or El Paso to come to Austin for medication. So yeah, really just none of it makes any sense right now, and that's why there were efforts to expand the law. There's continuing efforts, and until the law is changed, it's not really going to be that workable. But these folks who applied for the license, they want to give it a go. They want to give it their best shot and do what they can under what the law currently allows.
So as we speak about the state laws, it's also very important, as you mentioned, that federally cannabis is Schedule 1 substance. THC is Schedule 1 substance. Despite the fact that 0.3% THC seems to be a tolerable level on a federal level too, because it refers to food and food supplement articles. But in general, I think cannabis community, as I'm reading, especially in the last couple of months, are pretty shaken up with what may happen if Jeff Sessions, our current Attorney General, strikes the memo that keeps the federal government from infringing on the medical cannabis states and recreational states, and also promotes the federal asset forfeiture laws, putting them on the forefront, which have been used and abused in the past to basically take the assets from medical or recreational, more so recreational cannabis businesses. And so I will ask Benjamin to comment on this. How do you perceive this atmosphere, and how do you just think about the current situation? Let's start from that.
Well, it is correct, as you mentioned, that marijuana, cannabis, has been classified as a Schedule I drug for quite some time. And the politics surrounding that classification has been well documented by many different sources. And my personal views aside, it's patently incorrect as a classification from a scientific perspective. Now, what it takes, it was actually a question that I thought maybe we'd pose to Lisa, the changing of the classification from Schedule I to perhaps Schedule II, it would be obviously in order. I haven't seen that much on it. I'm not sure if you would like to comment on that.
Yeah, well, first of all, I would say we wouldn't want it to go into Schedule II, because then you've got to go to your doctor to have it prescribed, and then that brings in big pharma and insurance and all of that. So what we would really want to see is deschedule. We would want to see it come off altogether, so that states can do with it what they will, whether they want to allow it to be used recreationally or allow it to be researched for scientific purposes. And that's what a lot of local governments have been petitioning the DEA for years and years and years. So about a year ago, the DEA responded to another round of these petitions on August 11th and said, nope, we're going to keep it on Schedule I. We don't see any medical benefit to cannabis whatsoever, but we will loosen up the restrictions on research, and we will let you apply to research it. So that was a year ago, and they've received 25 applications, and they've taken no action on any of them.
So it kind of brings us a little bit to talking also about, I think, what's contradicting from, at least also from the federal government, is the fact that the U.S. government actually owns a patent on cannabinoids. It's U.S. patent 6630507, which is cannabinoids as antioxidants and neuroprotectants. And it actually states, and it's filed by U.S. Department of Health and Human Services, it states that cannabinoids have been found to have antioxidant properties. The newfound property makes cannabinoids useful in the treatment and prophylaxis of a wide variety of oxidation-associated diseases. And further, they say that it has applications as neuroprotectant, for example, in limiting neurological damage following, and now you have a slew of disorders that are listed on this patent: ischemic insults such as stroke and trauma, treatment of neurodegenerative diseases, which is essentially most of the neurological disorders, but they list Alzheimer's and Parkinson's disease, as well as dementia related to HIV. And they even state the non-psychoactive cannabinoids, such as CBD or cannabidiol, are particularly advantageous to use because they avoid toxicity that is encountered with psychoactive cannabinoids at high doses. So United States holds this patent, and if you want to proceed and, for example, patent any formulation, now if it has anything to do with cannabinoids and you have a finding on cannabinoids, the correct way, I believe, would be to obtain the investigational new drug status license from the federal government, which then allows you, through their license to formulate a cannabinoid or cannabis-based drug. Is that the way that it goes?
Yes, that's basically correct. And with regard to that patent, there is a great deal of irony, of course, that the U.S. government has that patent. The work originated in the National Institutes of Health, and the U.S. government does seek patent protection on its own inventions, and it did in this case. Within the patent world, there are patents that are related primarily to chemicals, where there's a great deal of chemical synthetic work that's conducted on a particular chemical scheme, and the claims in the patent, that part of the patent that legally defines the invention, is related basically to chemistry. And the recitation that you gave of the types of diseases that can be treated by those chemicals that are defined by the patent, it's very common where in those types of chemical patents, meaning patents that cover just a variety of chemicals, that the pharmaceutical company or the applicant will include an entire laundry list of diseases which can be treated, typically without any particular scientific support. So that it's not unusual to see that. It may or may not be taken as evidence that those chemicals have been shown to produce any therapeutic value. Not to say that they can't or don't, but it's very typical within a legal document for the attorney to try to make the claims as broad as possible to cover as much subject matter as possible. Going back to your original question, if a particular drug candidate is found to be one that the company wants to explore, then an investigational new drug application, or IND, would be the first route to go.
And maybe you could continue commenting. So what is the cost of IND? About $1 million? Or is there a cost that is upfront cost that the company has to pay for the license to the U.S. government? How much does the U.S. government collect for each investigation of new drug status they offer in cannabinoids?
Well, I don't think I can give you an exact amount, but let's say the estimate for any drug. I can remember when I was a graduate student in pharmacology, which is drug biochemistry, was very common to look at these types of statistics. The amount of money that it was considered to take to bring a drug to market, from bench to clinic, in other words, from invention to prescription, was considered to be maybe $100 million. Now it's dramatically increased in cost over the last generation, as pretty much everything else has, and I don't think there would be any difference in the cannabinoid world at all. No.
So then I was reading this interesting article. The author's name is Julie Weed, which I'm not sure if it is a real last name or if it is a... Is it? It's not a pseudonym? Okay. But it's a very interesting article that was posted on LinkedIn and Entrepreneurs Startup Life. And it's about basically what are the areas in which the companies are filing cannabinoid patents right now. And a lot of it has to do with cannabis and cannabinoid compositions, new drug formulations, new formulations with cannabinoids, and also new methods of preparation, possibly cannabinoid isolates or similar methods of maybe delivery of cannabinoids to the body. And then the second is characterization of these compounds and as far as they engage with endocannabinoid system. So it's very important that you brought it up, and the reason why there is patenting going on is because of the endocannabinoid system, because of the receptors and the fact that we can monitor on these receptors and as it interacts with endocannabinoid system. Now, I would like to comment here that we now know that cannabinoids and many components of cannabis interact not only with the endocannabinoid system, but with many other systems in the body. They in fact bind to not only cannabinoid receptors, CB receptors, but they also bind to transient receptor potential vanilloids, TRPV1 receptors that are intricately involved in the pain pathway mediation. They affect serotonergic or serotonin signaling, which is involved in food intake and mood regulation. So cannabinoids now, really, I think that this could be expanded, and this article should be noted that interactions not only with endocannabinoid system, but probably with a whole diverse system that interacts with other systems in the body too. And then obviously the third one is methods of treating diseases with cannabinoids that has been mentioned. And so I think that when I go to the cannabis industry meetings, people are very interested in patenting, but they cannot patent because the thing that people will say is that, well, you cannot patent a plant and you cannot patent a botanical preparation. Can you comment on that?
Sure. Well, so you can patent a plant, and you certainly can patent a botanical composition or extract. Within the cannabis field, there are very few plant patents, first it's important to realize that there are three types of patents in the United States legal system. There are utility patents, there are plant patents, and there are design patents. You can obtain patent protection for a plant patent, a type of a plant, and you can obtain patent protection within the utility patent field also. But the bottom line is, in the cannabis field, there are very, very, very few plant patents or utility patents related to cannabis plants. In the utility patent area, there are many patents related to cannabinoid chemistry and some of the areas that you discussed, such as extraction techniques, methods of production, large-scale production of chemicals, methods of treatment of diseases, and so on. In the patent world in general, there are certain types of patentable subject matter. Just the classifications in general are referred to as patenting a chemical, patenting a mixture of chemicals we refer to as a composition, patenting an article of manufacture, which would be basically a medical device, and you can obtain patent protection on methodology. Historically, it tended to be manufacturing processes, and in this particular area of cannabis technology, that would be in the fermentation or extraction fields, the chemistry of producing the cannabinoids or these terpenoids and so on.
Can you distinguish between patent and trade secrets, and how one goes about potentially protecting trade secrets?
Sure. So, just by way of background, of course, patent law is based in the United States Constitution. The individuals who wrote the Constitution were inventors like Benjamin Franklin and Thomas Jefferson, and they were highly interested in intellectual property, which is a term that you hear a great deal, which means that it is a type of property that under the legal system you may own by virtue of having created it using your intellect. And just like your personal property, say your car, has a piece of paper called a title that has a bunch of numbers and letters on it. A patent is a piece of paper that has our use of language, in our case English, to define an invention. And the invention is defined by a section in the patent referred to as the claims, because the applicant for the patent is claiming that they invented something. And in the claims, you recite, using language, what your invention is. A trade secret is any type of information that a company or an individual uses within their business context that they maintain as a secret and they use to their advantage. The quid pro quo for a patent in the United States system, and most other jurisdictions as well, of course, is that in return for the patent right, which is a right to exclude others, the applicant for a patent and the patentee makes a full disclosure of their invention. It's important to note that right of exclusivity is not one that allows the patentee to use their own invention. You may invent something and not be legally allowed to use it. You have, in contrast, the right to exclude all others from making, using, selling, or importing for sale the patented product or methodology. It is possible that you invent something that you cannot yourself sell. Typically, I give an example of a pencil. At one point, someone invented a pencil, and you might have a claim and a patent to a pencil as a lead-filled writing instrument. And subsequently, someone thought it would be a great idea if they could have a way of erasing the lead print on a piece of paper, and they attached an eraser to the end of the pencil. And they perhaps had a patent that recited a claim along the lines of a lead-filled writing instrument, wherein one end of said instrument contained a means for erasing the print written by the instrument. In that scenario, the person who invented the pencil couldn't sell the pencil with the eraser on it, and the person who invented the pencil with the eraser could not sell his own product without a license from the person who invented the original pencil.
So we were out of pencils for a while.
That's part of what spurred the digital era, I guess. A trade secret, of course, is something, as I said, that is kept secret by the owner, in contrast to a patent, which expires 20 years from the date you applied for the patent right. So typically patent rights will expire some, say, 15 or 16 years, sometimes more, sometimes less, from the date that the applicant applied for the patent. Trade secret can be held as a secret indefinitely. The most famous example, of course, is the formula for Coca-Cola, which was never patented, maintained as a trade secret, and it's something that's amenable to being a trade secret because it's not something that apparently one can easily reverse engineer. There's no there's no soda or cola that tastes like Coca-Cola, despite the many other colas that are out there. So if you have something that is difficult to reverse engineer, difficult for someone to discover what your secret is, then it may be more beneficial for you to maintain your intellectual property or your know-how as a trade secret.
That is terrific. Thank you very much. In the cannabis industry, there's a lot of respect that is given to know-how and trade secrets, because a lot of the businesses and entrepreneurs were operating in a clandestine-like fashion in developing specific strains and in developing extracts from these strains. How does one evaluate how difficult or how easy it is to reverse engineer a product?
Okay, of course, that's a very difficult question. I'm not sure that I have a very good answer. I don't think that there is any particular formula, and it's going to vary dramatically, but from subject matter to subject matter. Within the chemical fields, for example, I think reverse engineering is much more straightforward. If you have compositions that contain a variety of constituents, it may be more difficult for an entity to reverse engineer and know what's in the composition. For example, if you have, say, a cleaning composition that's used in an industrial process, it can be very difficult to determine what's in such a composition. So it's something that's going to be a case-by-case analysis, and there's no simple answer.
And in my experience, I also encountered, and I also thought about it myself, small and medium-sized businesses not wanting to patent things because they are afraid that they will give away the formula, or they will give away a method of preparation. And being that they're small or medium-sized, then what are the chances and how often do people pursue patent infringement lawsuits?
Well, that's a good question. It's also a difficult area because small companies can easily be overwhelmed legally by much larger companies, and the legal system is not necessarily amenable to fair play in that regard. So it is a concern, but the patent field has changed in this regard. A generation ago, for example, it was extremely unlikely that a law firm would take a patent infringement case on a contingency basis. In other words, not charge the attorney time, the legal services on an hourly basis, but they would receive a percentage of the judgment if they were successful, in the same way that personal injury and tort attorneys have practiced for many years. But of course, as the information age progressed and patenting became critical in the not just in the biotechnology and pharmaceutical world, but also in the computer science and electronics world, more and more law firms have endeavored to seek out patent infringement cases on a contingency basis. And so that makes it much more possible for a small company to fight a much larger entity in the legal arena.
And maybe just to kind of finish up on this topic on trade secrets versus patents, can you comment a little bit about the process itself? Let's say the cannabis company has an invention. Let's say it's a method of producing a cannabinoid formulation. They're not sure they want to give it away to the broad society. They don't want to publish it because they're afraid the bigger company is going to steal their idea and this technology. They are now faced with, I would understand, two options. One of them is try to protect it as trade secret, or try to patent it. What is the comparison of the two in the cost and in the timeline of protection of the trade secret? Not in the timeline as long as it's going to be active, but in the protection and the cost.
So for the trade secret, there's essentially no cost because the company need only keep it secret. There are obviously guidelines in order to maintain the secrecy. There's things that the company should not do and so on, but it does not involve hiring an attorney to maintain your trade secret. Within the patent context, it's a different story, of course. The patent application process varies according to technology, and certainly it varies according to the law firm and even geographically. Law firms in different parts of the country charge dramatically more. The patenting process in the United States is somewhat expensive, but not as expensive necessarily as in other jurisdictions. But filing a patent application to securement of a patent in the United States could be as little as $5,000 to $10,000, $20,000. It varies dramatically on a number of different factors. And again, trade secret is not something that requires an output by the company, and they can maintain the information as secret for as long as they want.
So that leads me to thinking about this huge medical center that we have in Houston and the potential for medical cannabis and for different formulations to be developed and tested in this giant medical center, which makes me think that Texas, in a way, is in a special position in this very slow, almost self-inflicting to its own program approach is not going to allow for cannabinoids or cannabis to be broadly researched and studied in humans, potentially at the medical center here. Can you comment, Lisa, maybe what are, the states in Colorado, for example, they have raised a lot of money from recreational cannabis. Can the states raise as much money for medical cannabis? And also, what are the bad things for the states from cannabis that Texas could learn about and potentially use the medical center to its advantage, or the land that we have for cultivation purposes? How do you compare these two states? What are some of the bad things, good things, and maybe lessons we could learn from Colorado and do it better in Texas, although it may take longer?
Yeah, absolutely. Well, as far as the revenue you're referring to, that's tax revenue from the sales of marijuana to the public. So there's two types. There's recreational and there's medical. So medical has a much lower tax. I'm just going to throw out a number. It's not correct, but let's just say it's 7 or 8% compared to around 25 or 27% for a recreational product in Colorado. And so they have put that money toward schools, repairing their schools, building new schools, roads. Some of the last numbers from 2015, so this is old, you can imagine it's exponentially higher now, but they had sold $1.3 million in product and generated $25 million in tax revenue. So Texas is 5 times the size of Colorado, so just multiply that number times 5. If we had it here, there's definitely a lot of interest in it for both medical and adult use. So Texas could raise a lot of money through taxing and regulation. I think it's been great for Colorado overall. There are some differences, some things that the Texas statute, the groundwork that has been laid for perhaps a future program for medical marijuana is got some good points that are a little bit better than Colorado. For example, you know how in Texas we have dry counties where you can't go buy beer or wine. It's like that in Colorado. Counties can opt out. So really the majority of Colorado is kind of conservative, and they outlaw marijuana altogether. So It's really just the urban areas that allow dispensaries, and some cities are medical only, like Colorado Springs, for example. So the negative to that, to being able to opt out, is that businesses will invest in, say, a large tract of land, or they'll start to build their facilities, and they work toward applying for a license, and all of the many millions of dollars that costs. And then opponents can come along and persuade city council, and it's all politics, to decide to outlaw marijuana, and then or outlaw a certain type of dispensary, or outlaw a certain type of thing that has already been underway. So that's kind of a negative thing, that Texas is already on the front end, kind of with the typical free market enterprise, pro-business type of environment that we have here. That's written into the Texas law already. I think that we could learn from Colorado. I think that they're directing their revenue, their tax revenue, to new schools. So there's some frustration that existing schools could use some of that money. So Texas could frame that. I know we've got a shortfall in education consistently year to year to year. Texas could really do a lot better job in how they craft that and direct a lot of money toward schools, to law enforcement. I mean, there's a lot of areas that I think that would be music to the ears of a lot of agencies in Texas. And yeah, with the premier medical center that we have here, the cancer center, I mean, they're doing amazing things in Israel, for example, where people will send dissections of a brain tumor over there, and they will figure out formulations that will go in and attack that particular type of brain tumor and cause it to shrink. And same thing for cancer. And we could be doing work like that here in Houston. And there are so many patients that, could really, really benefit from that type of research.
So recently I had a discussion with the Houston Forensic Sciences Center, and they also anticipate that they will have to deal with driving while smoking cannabis, driving after smoking cannabis, driving on cannabis edible or extract. And there's a road test that is usually used for evaluating somebody's alcohol intoxication level. Now, we know from studies with driving, it's conflicting information that's coming out, in the sense that there seems to be more accidents, and people that are found in these accidents in Washington State, I believe, are consuming cannabis. I don't know if the correlation was also there with the use of alcohol and use of cannabis, but there is another study that shows that cannabis users that are experienced cannabis users, it doesn't really affect their driving skills. And the first-time users, their driving skills are, in fact, affected. And so I think that it's very important for Texas to have this very open discussion about everything. Open discussion about laws, how to change the laws, how to do the research, how to do the medical research, how to protect the public, because a lot of it has to do with education, but a lot of it also has to do with science. We recently, just a couple of days ago, published an article on synthetic cannabinoids, and we showed drastic differences in physiological and psychological effects when a person has consumed synthetic spice or synthetic kush, which is not real cannabis, synthetic marijuana. But the society, and a lot of times even forensics people, perceive it in a similar light because there isn't enough science behind it. I think forensics people are probably leading the charge. It's not the police. I think they're educating or trying to be on the cusp to educate the police how to behave. But at some point, I think that all of the communities have to come together and to have a proper evaluation, whether you can drive the car, and proper patenting systems set up so people are not scared to patent because they think what they're doing is federally illegal. And this also brings me, I think, to one more question that I had for perhaps both of you. There are many investors that are looking at cannabis industry right now with the mood that Jeff Sessions is inflicting in Washington, D.C., there is a potential slowdown, I think, of these investments, and there is some sort of a thoughtfulness in the industry and with the investors, whether it is still safe to be investing in this industry. But at the same time, there are a lot of auxiliary businesses that do not grow cannabis, that may just develop technology that they developed for chamomile, but now it can be perfectly repurposed for cannabis. Maybe they're educational companies, maybe they're consulting companies, maybe they're formulation companies that work globally because the market is global. A lot of cannabis products that are hemp products in the United States are foreign produced products, European products, even Chinese products. So it's a real global market. But how do you see, should the auxiliary businesses feel safe? Should the investors feel safer with auxiliary businesses rather than ones that touch the plant itself or the extract or works with products? What are your perceptions in this respect?
Well, it's fraught with uncertainty, even under the Obama administration. So it was never safe. But there is the 2014 Farm Bill that makes some allowances to prevent the use of federal funds for DEA agents to go out and bust medical marijuana businesses that are operating within a robust state program. But that has to be renewed every 6 months or so. It could expire in September and not be renewed. Jeff Sessions has personally written a letter to his fellow congressmen asking them not to renew that. I think it's well known that he's got personal opinions against marijuana. He equates it with heroin, says lots of things about it. Traditionally, medical marijuana has been considered a little bit safer to invest in because it has those protections under that 2014 Farm Bill Act, and the regime of under the Cole memo of the Obama administration, it's just favored medical businesses. So they feel like they have a little bit of cover, whereas recreational is just way out there with the federal one designation that's been freshly reaffirmed a year ago. So given the temperature and the unpredictability of this administration, it's not known yet what Sessions is going to do. On the campaign trail, Trump talked about favoring medical marijuana, but he hasn't really said anything since he's been in office one way or the other. So it's just, times are just really uncertain right now. There have been investors being a lot more cautious, and if they have their choice, going with a medical company, or as you said, a company that does not touch the plant, some kind of, because the cannabis industry is an industry like any other, and it needs all types of vendors and suppliers, and you can invest in one of those other types of suppliers or vendors and still be taking part of the industry and investing and moving the ball forward without exposing yourself to the federal risk of being involved with the production of marijuana itself. So that is a much safer way to invest. It's kind of considered a more passive type of investment in this federally Schedule I substance.
Also, if you could, Benjamin, if you could comment about the same, but also from the perspective of maybe investors and how they would look at trade secret versus a patent for the alcohol.
Okay, sure. So I think I'd only add a little to what Lisa commented, and that is that despite the current political climate, I think that the industry is moving in one direction, and I think that experience illustrates that it's very difficult to turn the tide of public opinion once it starts to turn. And over the last generation, the opinion of the public has obviously turned with regard to not only recreational use of cannabis, but of course medicinal use of cannabis. There's a great deal of misinformation. I like to say that as much as we're in an information age, we're in a disinformation age, and I said that long before the whole fake news thing started. But it's absolutely true. If you do a search for anything in the field of medicine on the internet, the first 10 sites that will appear in your results, 8 of them will be bogus sites trying to sell you something, and 1 will be the Mayo Clinic and maybe the Cleveland Clinic. But there's a great deal of disinformation out there, or misinformation. But I think the field of cannabis has changed in the mind of the public, and political pressure by the public should not be discounted. And you can see it obviously in other political issues over the last generation. Look at what has occurred with sexual orientation in marriage and so on. When there is an organized effort on behalf of a particular special interest group, it may take time, but it will eventually yield results. And within medical cannabis, there's certainly fruit for mining its potential therapeutic efficacy in a wide variety of conditions. Most people maybe are not aware that most of the pharmaceuticals sold throughout time are plant-based. They weren't ones that were just, they're not drugs that were just synthesized in the lab out of the blue, but there are many, many examples. I think about 60% of all drugs are plant-based. And cannabis is another plant that has a chemical that could be altered into forms that may enhance our opportunity to treat a variety of diseases. In the patent field, I think that companies are continuing to seek patent protection. There's been perhaps somewhat of a slowdown within the university realm, but there's been an increase, obviously, in small startup companies relating to cannabis technologies of all sorts.
Great. So thank you very much. I thank you both for a very meaningful discussion. I think, Lisa, you mentioned in one of your talks that Texas started cannabis prohibition in 1919. So the next legislative session marks 100 years of maybe ending cannabis prohibition. And we are very happy that you have contributed some really interesting thoughts. It's a growing field. It's a field that's sorting itself out from every perspective, from business perspective, from legal perspective, from science perspective, from medical perspective. It's a paradigm changer for a lot of healthcare practitioners because they have to step out of their comfort zone and operate within a realm of medical cannabis that's non-prescription, that's not federally approved, that they don't necessarily have enough of the information on how to administer it or select products that are consistently producing the same formulations and the same concentrations of cannabinoids. But I think it is really worthwhile for us to have these discussions to inform the public, to inform our viewers about what can be done in Texas, and involve everybody in this discussion, from attorneys to business people to scientists to medical doctors to police officers. in hopefully creating a really sensible policy that's sensible for everybody, for patients and for business owners as well. So thank you very much, and if audience has any questions, I will ask for you to just stick around and ask them directly, and thank you once again.